Hello, everyone. Welcome to Court with Krissy. Today we have a defaulted dad who denies that he is the father, and the baby's mother agrees. The only problem, it's presented by the prosecutor. I hope you like it. Court with Krissy is now in session.
What's that?
We're in a courtroom. Yes. Please take that off. Ma'am, on the telephone line that I've admitted, are you Lavette Rose Peelpole?
Yes.
All right, welcome. So, Mr. Higley, we're here today because the prosecutor's office in this DP case rather, has asked, I was right the first time, I apologize, DS case has asked me to enter what's called a default judgment support. Are you aware of that?
Yep. Yes, Your Honor.
So the default was asked to be entered back on February 13th, claiming that you were served with a copy of the summons and complaint and that you did not answer, therefore a default was entered against you. Are you also aware of that? Are you also aware of that, Mr. Higley?
Yes, Your Honor.
All right. So were you here just so you could hear what was happening, or were you going to be asking the court to make some sort of a relief to you regarding that default?
Can you repeat that?
Sure. So were you here just to hear what was going on with the judgment, or were you going to ask me to participate in some fashion?
Participate. I even met with Kara. It was a couple days after the summons, but the summons was sent to my ex-girlfriend's house, not my address.
Well, here's my request for you first. The default judgment of support, if it's entered, would appear to state that Lavette is the mother of and you're the father of Parker, and that Lavette would have custody of the child and physical custody, and that you will share joint legal custody of the child until further order of the court. Are you aware of that purported order?
Yes.
It would also be an acknowledgement of paternity. Otherwise, it would be a court finding that you are the father of Parker Henry Cole Higley. Are you aware of that?
Yes, Your Honor. As far as I know, there was DNA taken, which by Mike Rolla and Luke Hamlin from the drug court team. And when I was in contact about the findings, supposedly the DNA just came up missing. So
the question,
I'd like to know where that went.
Are opposing or objecting to any of those findings? Are you opposing or objecting to any of those findings?
About him possibly being mine? Yeah.
So you have a specific and very clear legal obligation then, Mr. Higley, which is that the default is in place. And a default being in place, meaning the court has an obligation to simply have the default continue, and when a party asks for a default judgment, to enter it without hearing from you, unless and until you have the default properly set aside. Having a default properly set aside involves application of the court rule, but that court rule applies to you as clearly as it applies to me. So I'm going to tell you the court rule number. If you file within a time period that I'm going to set in a moment, a motion to set aside the default and have it set aside, then you're going to be able to be heard on the merits of this case. If you don't have the default set aside, you won't be able to be entitled to be heard on the merits of this case, and I'm simply going to enter the judgment because you have not otherwise answered against the complaint that was served. So I'm going to tell you the court rule, and then you're going to have an obligation within a time period that I'm going to set in a moment to file a motion to set aside the default and to follow the court rule explicitly. Because the way this law works is if you don't follow it explicitly, I can't grant the relief that you're going to ask for, which is to have the default set aside. So the court rule in play is Michigan Court Rule MCR 2.603. And a part of that court rule is in regards to setting aside a default judgment. That has particular rules and it has particular obligations. There's also Michigan case law that further clarifies those things. I recognize, Mr. Higley, you're not an attorney, but you are bound by those case law requirements. So if you don't know them, how to set aside a default, you better learn them and understand them, because I assure you, Mr. Rolla will rely upon those written legal obligations just as sure as I clearly have to. So if you don't know what they are, there's no way you can meet them. How long would you be asking me to give to file a motion to set aside the default?
No more than 2 weeks.
Mr. Roll, I recognize that if I asked you, your first order of business would likely be to ask me to just simply enter the default. But given the circumstances, I'm likely to provide at least a brief, reasonable opportunity for Mr. Higley to file a motion and see if he can get it set aside. Did you want to be heard on either of those things before I ask you what an appropriate time period is?
I do, Your Honor.
Go ahead.
The provision which the court's referring to Mr. Higley on, I respectfully submit does not apply. He signed an affidavit of parentage. That's what the default is based upon. Since he signed an affidavit of parentage, he's not even entitled to DNA testing.
Well, then what's the prejudice? If he files it and that's the state of the law, I'm going to side with you and I'm still going to issue the default judgment, right?
I understand that, Judge. I just wanted I wanted to make sure you were aware of that fact in regard.
No, I appreciate that. That's a little bit different than just failing to answer, but if you're right, he won't be able to meet the meritorious defense part of the default judgment setting aside, right?
I would hopefully agree. Yes, Judge.
All right. Well, Mr. Higley, I'm going to provide you 2 weeks. Today is May 9th. If you file your motion to set aside the default within 2 weeks, that is by the 23rd of May, I'll consider it timely. If you don't, then I won't consider it timely. If you timely file, then you're going to have to meet the court rule obligations. But be aware of what Mr. Roll is also claiming. And if he's accurate, he may be able to convince me that Michigan law is going to control. If you signed an affidavit of parentage, then that affidavit of parentage might be controlling in terms of whether or not you can show under that court rule that I cited any meritorious defense. I'm not going to decide that now, but you should consider that when you file your motion to set aside a default. Because if you did sign an affidavit of parentage, and unless that is set aside, it might be controlling upon my exercise of discretion. But I'll give you 2 weeks, Mr. Higley, to seek that as an answer or seek it as a motion. But if it's not filed within 2 weeks, I'm not going to review it at all. And then you're going to still be and remain in default. If you convince me that I should set aside the default, then I'll hear you on the merits. But if you can't convince me, I'm just going to set a new hearing next month and I'll get the judgment entered. And then you're free to do with it whatever you want after I enter the judgment. Do you have questions regarding how we're going to proceed right now, Mr. Higley?
No, I guess my only question was about the DNA that the prosecutor set aside for drug court to take from me.
Mr. Higley, those are issues that I will answer if they're properly before me, but I'm not going to answer legal issues until it's in front of me properly. You've heard the prosecutor's statement, and I haven't made that as a ruling yet, but you've heard the prosecutor's statement and claim that under Michigan law, since you signed an affidavit of parentage, you're not entitled to a blood test. I'm not making that finding right now, but if it's presented to me and if I'm asked to make that finding and the law supports it, then I'll make the finding however the law supports it. But other than that, you're free to bring up any of those other questions in writing to the court. That's what the motion is for. Once properly before me, I will address them. Ms. Levette, Ms. Leopold, I'm going to have a hearing set in about a month. Then I'll have some follow-up discussions with you, with Mr. Higley, and with Mr. Rolla. And ultimately, maybe we'll get the judgment entered, or maybe we'll have to go in a different way. I appreciate you being here, Ms. Leopold. I'll set this matter for next month, and we'll see how we're going to proceed. Thank you, everyone.
Judge, a housekeeping matter.
Thank you,
Judge, a housekeeping matter while we're on the record.
Mr. Rolla, go ahead.
Mr. Higley indicated he has.
Hang on, Mr. Rolla. I'll hear from you in just a moment.
Mr. Higley indicated he has a new address. I'd ask that he provide that address and the current phone number to the court.
Mr. Higley, are you at the 252 Ramblewood address?
Correct. And the prosecutor actually made, and that was never my address.
Well, that's fine, Mr. Higley, but I have the correct address. I'm asking because I send notices. The question of service, though, Mr. Higley, is not just did it get mailed to the right address. It's whether or not you were aware of it. It appears clear that you were aware of it because you keep talking about the fact that you knew where it went. In any event, I'm not making that as a finding right now, but it might impact and enter my mind later. I just needed your address so that I can send a notice to you. Now I've got it. That notice will be for next month, about this time in about 30 days. We'll see everyone at that point. But this question, Ms. Leopold, did you have a question?
Yes, Your Honor.
Go ahead.
My question was, is there any way I could get a hold of Michael Rolla to figure out if he did send in that DNA or test or not? Because from my knowledge, he has not spoken to me about it, and my caseworker has not known anything about it. And I would really like to know if Joshua is my son's father or not, because I do not believe he is.
Well, so that's a fair question, but I'm going to direct you, just like I would direct you at any time. You have a representative, Mr. Blumberg's here on behalf of the people. You can contact his office. You can contact the Victims Advocate's office, and they can either put you in contact with Mr. Rolla or he won't speak to you. But in this particular case, I'm not going to take docket time because I simply don't have it to address whether or not you can talk to Mr. Rolla. You can try to reach out to his office. He'll speak to you or he won't. If he feels he has an obligation, I'm sure he will. If not, I'm sure that he won't. But I'm not going to direct that, and I don't have the ability to do so, again, absent a proper motion. So I understand your concern, Ms. Paul, but I'm not going to address it further, at least not yet. The court will be in recess today. I will reset this for next month, though. You'll get a notice in the mail as well, Ms. Paul. Are you still at?
Yes.
All right, thanks. We'll be back next month to hopefully have some resolution to these issues.
All right. Thank you.